Ever wondered how to navigate the intricate web of compliance processes while maintaining top-tier security for your notarial records? The solution is closer than you think. Introducing ComplyChainGuard, or CGG, a platform designed specifically for civil law notaries. CCG merges the complex chain of compliance processes with unrivaled protective measures. It enables you to stride confidently through the multifaceted terrain of regulations while ensuring paramount security for your records, deeds, and transactions. CCG boasts a regulatory compliance engine that keeps you updated with real-time insights tailored to civil law regulations. It effortlessly integrates with legal databases and ensures automated compliance checks for all notarial deeds and transactions. But that's not all. CCG also features advanced encryption to safeguard your notarial records. You'll benefit from multi-factor authentication and periodic security assessments, upholding the sanctity of every notarial act. Plus, with continuous transaction monitoring, you'll receive alerts for any discrepancies and comprehensive logs for traceability. And when it comes to reporting and analytics, CCG generates automated compliance reports specific to notarial acts. Dive into our analytics dashboard for transaction patterns and predictive insights. Why choose CCG? It brings efficiency, security, and compliance to your fingertips, allowing you to operate with unmatched confidence and credibility. CCG integrates effortlessly with your notarial record-keeping systems. Our API facilitates bespoke integrations, ensuring compatibility with major legal platforms and databases. And remember, our dedicated support is here to assist you every step of the way. CGG is the future of notarial practices. It redefines your work, ensuring accuracy, credibility, and peace of mind. It's a transformative experience tailored for civil law notaries. Don't wait. Contact ComplyChainGuard for a demo or more information. Step into the future of notarial practices. Your journey to seamless compliance and robust security starts with CCG.
Have you ever pondered the integral role of truth and transparency in legal transactions? Indeed, these principles form the very bedrock of justice and fairness. In the realm of affidavits, truth and transparency are paramount. They are the compass guiding the navigation of complex legal waters. But how can we ensure these principles are upheld consistently and efficiently? Enter Affinet, the Affidavit Network. Affinet is a groundbreaking platform designed with sovereigns, legal professionals, and businesses in mind. It is a one-stop solution for creating, verifying, and recording truth affidavits. This ensures a seamless and trustworthy experience for all parties involved. Why choose Affinet? Integrity, efficiency, security, and expertise. Our platform is built on the principle of truth, fostering transparency in each transaction. Record your affidavits with ease and access them anytime, anywhere. With state-of-the-art encryption, your documents remain confidential and secure. Plus, our team of legal professionals is always on hand to assist and guide you. Let's delve deeper into the features of Affinet. Draft your affidavits online using our user-friendly interface. Ensure the authenticity of your documents with our robust verification system. Record your affidavits in county records or publish them as required, thanks to our seamless integration with the public record. Track the status of your affidavits and receive notifications on any challenges or updates with our case management feature. Affinet is also compliant with RSIA, the Arbitration Registry Investment System Artificial Intelligence. This ensures we uphold the highest standards in the creation and verification of truth affidavits. What exactly is a truth affidavit? It's a formal written statement made under oath, asserting the veracity of specific facts. All affidavits are inherently considered to be truth affidavits, as they are the primary means for a sovereign to communicate with another sovereign or government entity. Affidavits play a crucial role in common law. They present only facts that the author can prove and are primarily used in commercial transactions and disputes. When recorded in county records, they become part of public policy and establish the facts of a case. If unchallenged for 30 days post-recording, they become the law of the case. It's essential to remember that public policy is established for public officials, not sovereigns. Sovereigns operate in the private domain, while the government operates publicly. Affinet simplifies the process of using affidavits in corporate courts. Record the affidavit in the county record, obtain 3 certified copies from the county clerk, and submit 1 copy to the court records. Present 1 copy to the plaintiff and another to the judge during court proceedings. As the author of the affidavit, you become the creditor or secured party in the case, and the case cannot proceed until your affidavit is challenged. A truth affidavit must be truthful and complete. It should clearly identify the author as a sovereign private person, living sole, creditor, claimant, and secured party. The affidavit should only state facts that are irrefutable. In conclusion, Affinet is your trusted partner in truthful transactions. For your next affidavit, give Affinet a try. Experience the difference of a platform built on the principles of truth and transparency. Affinet, your partner in integrity.
Understanding syntactical trust training and insurance documentation. Summary. The video presentation discusses tactical trust training and the role of automated underwriting software in securitization audits. The focus is on the DTCC Replacement Implementation Guide linked to Accord Life and Annuity Standards, revealing its correlation with global insurance standards. Various insurance forms and their functions are explained, including property loss notices, liability notices, and certificates of insurance. The video also touches on specialized forms for different types of insurance and the use of forms in arbitration processes. The presentation emphasizes upcoming in-depth training on syntactical trust banking and M3 conveyances. Highlights. First, the video introduces tactical trust training and the use of automated underwriting software for securitization audits. Second, the DTCC Replacement Implementation Guide is tied to global insurance standards and correlates with Accord Life and Annuity Standards. Third, various insurance forms such as property loss notices and liability notices are discussed, along with their roles. Fourth, specific forms for different types of insurance like trucking and commercial property insurance are highlighted. Fifth, forms play a crucial role in arbitration processes, populating based on requests and activities. Sixth, the presentation mentions specialized forms like those for professional liability, money transmittal bonds, and key man insurance. Seventh, Forms 831 and 833 are emphasized for reporting claims involving lawyers and other professionals. Eighth, the importance of gathering materials for upcoming in-depth training on syntactical trust banking and M3 conveyances is highlighted. Understanding syntactical trust training and insurance documentation. In the realm of financial operations, syntactical trust training plays a vital role in ensuring compliance and effective implementation of automated underwriting software. This comprehensive guide sheds light on the intricate world of insurance documentation, aiming to equip compliance officers and insurance professionals with the knowledge necessary for accurate and informed decision-making. From the correlation between global insurance standards and automated underwriting to the utilization of specific forms in various insurance scenarios, this article dives deep into the core of syntactical trust training. The role of automated underwriting software in securitization audits. Automated underwriting software is a key player in the world of securitization audits. These audits are essential for evaluating the compliance and security aspects of financial transactions. By utilizing automated underwriting software, organizations can streamline the auditing process and ensure accurate assessments of various financial instruments. Understanding the DTCC Replacement Implementation Guide. At the heart of insurance operations lies the DTCC, Depository Trust and Clearing Corporation, Replacement Implementation Guide. This guide, rooted in Accord Life and Annuity Standards, serves as a crucial reference for compliance officers and insurance professionals. It establishes a direct link between the DTCC and the CORE, which deals with global insurance standards. This connection is particularly relevant for those involved in commercial insurances, such as tractor-trailer insurance, where certificates of insurance originate from the CORE. Decoding the Accord Form Index. The Accord Form Index is a treasure trove of forms used in the insurance industry. From property loss notices to liability notices, this index encompasses a wide array of forms that cater to diverse insurance scenarios. For instance, individuals making claims on insurances will encounter forms such as Notice of Occurrence and Claim, Property Loss Notices, and more. Property loss notices. Notice of occurrence and claim. Intermodal interchange certificate of insurance. Certificate of property insurance. Certificate of liability insurance. Evidence of property insurance. Evidence of commercial property insurance. Statement of no loss. Financial responsibility form. Insurance binders. Commercial insurance application, Form 125. Accounts receivable for valuable papers. Professional liability supplement, Form 187. Money transmittal bond, shared report of execution, Form 501. Contract bond request, Forms 502, 503, 504. Professional special insurance application, Form 825. Lawyer's professional liability section, Forms 831, 833. Navigating the complexity of insurance documentation. The intricate web of insurance documentation comes to life through various forms that serve distinct purposes. From professional liability supplements to notices of incident or claim, these forms cater to professionals, specialists, and various insurance scenarios. For instance, Form 831 and 833 for lawyers and other professionals. Form 825, Professional Special Insurance Application. Form 501, Shared Report of Execution for Money Transmittal Bond. Forms 502, 503, 504, Contract Bond Requests. Property loss notices and notice of occurrence and claim, the reinsurance connection. Applying syntactical trust training in practical scenarios. As professionals navigate the world of insurance, syntactical trust training becomes crucial for accurate implementation. From understanding specific forms to using them effectively in various arbitration scenarios, this training ensures compliance and informed decision-making. For instance, Schedule C on Admiralty claim and notice of fault demand for payment. Cross-referencing forms for effective reinsurance. Embracing the future of insurance operations. As the industry evolves, syntactical trust training remains an essential cornerstone of insurance operations. This guide serves as a roadmap for compliance officers, insurance professionals, and all stakeholders involved in the intricate world of insurance documentation. By grasping the nuances of syntactical trust training, professionals can navigate the complexities of the insurance landscape with confidence, ensuring compliance and effective decision-making. In conclusion, syntactical trust training and a deep understanding of insurance documentation pave the way for efficient operations and informed choices in the insurance industry. This guide serves as a comprehensive resource for those seeking clarity and proficiency in navigating the intricacies of insurance forms and procedures. As professionals continue to engage with the evolving landscape of insurance, syntactical trust training remains a valuable asset that empowers them to make impactful decisions and contribute to the industry's growth.
Thank you for watching. Remember, this guide is a starting point. Laws and regulations may vary by jurisdiction, so always consult with a legal expert. See you in our next video. Why is it crucial to understand M1 assets and Schedule K1 tax disbursements in financial planning? That's a question that could make anyone pause. It's true these subjects might seem complex and intimidating, but understanding them is key to navigating the financial seas with confidence and ease. First, consider M1 assets. These are the most liquid assets in an economy, meaning They can be quickly and easily converted into cash. They include physical money, such as coins and currency, as well as demand deposits like checking accounts. M1 assets are the first layer of the money supply, providing the backbone for day-to-day transactions. Think of M1 assets as the lifeblood of an economy. They flow through the financial system, enabling transactions, driving economic activity, and offering insights into the health of the economy. Now let's turn our attention to Schedule K-1 tax disbursements. These are issued by partnerships and S corporations to their partners and shareholders. The forms provide information on each individual's share of the entity's income, deductions, and credits. Understanding schedule. K-1 is crucial for anyone involved in a partnership or S corporation. The information provided on this form can impact personal tax liabilities, and navigating its complexities is key to accurate tax reporting. In sum, understanding M1 assets provides insight into the liquidity and health of an economy, while grasping Schedule K-1 tax disbursements is vital for partners and shareholders in partnerships and S corporations. So despite the complexity of these topics, gaining a solid understanding of them is an investment well worth making. It equips individuals with the knowledge to make informed financial decisions, navigate tax complexities with ease, and ultimately chart a course towards financial success. As the journey through M1 assets and Schedule K-1 tax disbursements continues, remember, these concepts aren't just abstract ideas. They're practical tools that can help navigate the often turbulent waters of financial planning. With these tools in hand, the path to financial success becomes clearer, the journey smoother, and the destination closer than ever before. So, set sail with confidence, armed with the knowledge of M1 assets and Schedule K-1 tax disbursements, and chart a course towards financial success. In a world where laws govern every aspect of life, from the food we eat to the air we breathe, the role of a parliamentary draftsman is of utmost significance. Imagine a draftsman laboring over a piece of legislation that would change the course of a nation's history. The strokes of his pen, guided by his deep understanding of the law and a keen sense of justice, would shape the lives of millions. This is not an overstatement. The work of parliamentary draftsmen has far-reaching consequences, impacting the social, economic, and political landscapes of societies. So now, let's embark on a journey to understand the role of a parliamentary draftsman and the tools that can make this journey smoother and more efficient. In the first section, we delve into the role of a parliamentary draftsman. This role is pivotal in the legislative process, requiring a sound understanding of legal principles and frameworks. It requires essential competencies, including a deep understanding of law, policy analysis, and statutory interpretation. The second section introduces ARISI, an AI-driven platform designed to revolutionize the work of parliamentary draftsmen. Its intelligent arbitration engine enhances accuracy, compliance, and efficiency in legislative drafting. The notional pooling system and advanced notarial practices offered by ARISI elevate drafting capabilities and ensure compliance with civil law regulations. The third section highlights the importance of Comply Chain Guard, or CCG, in the legislative process. This tool ensures compliance with legal and regulatory requirements, streamlines compliance processes, and identifies and mitigates potential risks. In the fourth section, we explore AFINet, a powerful tool for policy analysis and drafting. AFINet's advanced research capabilities and drafting support enhance the clarity, coherence, and precision of legislative language. Finally, in the fifth section, we emphasize the importance of continuous learning, networking, and industry involvement for professional growth and development. To wrap up, by leveraging RISI, CCG, and AFINet, aspiring draftsmen can enhance their skills, expand their knowledge, and contribute to the development of impactful legislation. These tools, combined with deep legal expertise, ensure the creation of effective, compliant laws that have the potential to shape societies. So, gear up for a transformative journey toward becoming a proficient parliamentary draftsman. Ever wondered how to navigate the labyrinth of post-issue transactions in the insurance and retirement services sector? The answer lies in a comprehensive document known as the DTCC Fund Transfer Implementation Guide. This guide is the torch that illuminates the path, providing a robust framework for using web services transactions to efficiently manage these transactions, reducing manual errors and boosting automation. Enforced transactions, or IFT, brought to us by DTCC's Insurance and Retirement Services, marks a milestone in automating activities related to post-issue insurance contracts. What does IFT do? It facilitates real-time message routing between distributors and insurance carriers, ensuring smooth transactions across various operations such as financial withdrawals, fund transfers, and policy administration. Now let's delve into the guide's key components. First, we have the technical requirements and security protocols. The guide specifies the technical requisites for implementing IFT web services. This includes connectivity, message transmission, and the adoption of ACORD Life and annuity standards for data formatting. In terms of security, it recommends the use of certificates and secure SOAP headers to ensure data integrity and confidentiality. Next, we have the detailed message choreography. This section of the guide meticulously describes the flow of messages involved in IFT transactions, from when distributors initiate requests to when carriers confirm transactions. The guide delineates both asynchronous and synchronous message flows for clarity in communication between all parties involved. Now we come to the key transactions and their flows. Values inquiry and policy administration. Inquiry are essential for obtaining updated policy information, providing a snapshot of the current policy status. Then, we have the transaction requests and responses, covering the life cycle of a transaction request from submission to processing and response. Lastly, there's the Day 2 confirm, where carriers confirm the outcomes of transactions processed during the nightly batch cycle. The guide also specifies DTCC's operational hours for various transaction types, underscoring the importance of adhering to these timelines for successful transaction processing. It also addresses procedures for early market close days, ensuring that transactions are handled appropriately during these times. A significant emphasis is placed on the use of ACORD Life and annuity standards, which underpin the entire framework of IFT web services. The guide encourages the adoption of these standards for consistent and efficient data exchange across the
I am Allison Apple, the Marketing Manager at National Advisors Trust. Our presenter today is Barry D. Flagg, the inventor and founder of Veralytic Inc., the only patented online publisher of life insurance pricing and performance research and product suitability ratings. Veralytic is the product of his unique background as both the youngest certified financial planner in history, schooled in the investment business, as well as a life insurance practitioner consistently ranked in the top 1% of the industry. His experience in financial product analysis, life insurance sales, and marketing, and his success in managing large life insurance portfolios for affluent individuals and growth companies brings an unparalleled advantage to his presentations. Barry is a recognized expert in applying prudent investor principles to life insurance product selection and portfolio management, and has been published and featured in the industry's most read magazines and cited in legal and accounting books and journals. Everyone, please welcome Barry.
Thank you, Allison. Can everybody hear me? Allison, can you hear me okay?
Yes, we are good.
Okay, very good. Glad to be here. I was asked to address the exposure to liability that confronts estate planning attorneys specifically, coming out of an article that I helped co-write as it relates to life insurance in a trust-owned setting and really beyond. However, the trends that are discussed in the presentation apply much more broadly to professional advisors that include trustees. So some of the things we're going to talk about come from and are relevant to cases against statutory fiduciaries, like in the Cochran case and the French case. Veralytic Research is also bolted on to the largest third-party administrator of life insurance, of trust-owned life insurance for institutional fiduciaries. Think of it as in the same way that Morningstar is bolted on to or accessible from maybe the website for your 401k kind of thing. It is certainly relevant to attorneys. By sheer coincidence, I got a call from who has been caught up in a dispute where the life insurance policy failed to meet client expectations, and the attorney was the plaintiff attorney threw a very broad net to include the broker, the trustee of the life insurance trust, and the attorney who drafted the life insurance trust. And maybe the fastest growing group that has a target, that has the target of the plaintiff's bar, are insurance brokers. Insurance brokers are fiduciaries by case law in some states, and clearly now questionable marketing practices involving stranger-originated life insurance and 419 plans and 412I plans now have a fair amount of activity of the trying to assign the liability to insurance brokers. So while the beginning of this, the request to speak about liability here came from an article that I co-wrote with an attorney by the name of Neil Schoenblum that discusses the duty to advise clients, the duty that estate planning attorneys have to advise their clients regarding trust-owned life insurance. I intend for the my remarks here today to apply to all professional advisors in some way, shape, or form. And the article that was the impetus for this presentation talks about both the legal assertions or the legal risks or the legal liability, like rendering, for an attorney, maybe rendering non-legal advice, or having implied contractual obligations, or being found to have a continuing representation beyond the original engagement on the basis of some marginal contact with interested parties. Those are examples of kind of the legal liabilities or the legal aspects of this topic. That was the job of my co-author, Neil. My job was to discuss the economic liability or the economic risk or the economic areas of liability. And so that's what I will talk about today. If anybody does want either a copy of the Do Estate Planning Attorneys article, which was published in CCH, I think you can probably Google it, but if you want to just email me at bflag@veralytic.com, I'd be happy to get you a copy of the article and put you in touch with Neil for any attorneys who have questions about kind of the legal aspects of this beyond the economic aspects that I'll address. So we have a situation where more clients are being disappointed with the performance of their life insurance for some reasons we'll talk about. But it's not like we can do a whole lot about that because life insurance is integral to a lot of planning, where in estate plans where there is high concentrations of a particular asset that would be tough to liquidate, in buy-sell situations where closely held stock is next to impossible to liquidate, for income replacement, balancing the estate. I mean, it is integral to the estate planning that the estate planning attorney does, and it has 4 unique tax benefits that no other asset has. Tax-free death benefits, tax-free growth of cash values, tax-free withdrawals till up to basis on a FIFO accounting basis, and then whatever gains may be left in the cash values can be borrowed from the policy. So it's almost borrowing from yourself at very favorable interest rates without tax. And the death benefit, which is tax-free, repays the loans. So if I go to a bank, I've got to go repay the loan with after-tax dollars, and with life insurance, the loan gets repaid with pre-tax dollars, and they're not even my dollars. So it's got 4 clear tax advantages. It's as a risk management tool. It's integral to planning. But at the same time, results have fallen short of client expectations. The Cochran case I mentioned was a case about an insured who purchased, or as the case may be, was sold a universal life policy when interest rates were high and premiums were miscalculated based on the high interest rates, and the policy ended up being underfunded, so they exchanged it to a variable policy where they did the same thing. They calculated premiums, presuming unrealistically high earnings rates on the variable accounts, and again, those returns failed to materialize, and the policy remained undervalued. So they did another exchange to a guaranteed policy, and shortly thereafter, shortly as in 6 months thereafter, the insured passes, and the beneficiary sued for the difference between the death benefits they actually received and the ones that they thought, or the death benefits that were actually in place prior to the last exchange, and it was a $6 million difference.
Welcome to Section 1, Introduction, the significance of tax codes and trusts. In this section, we will explore the critical roles these elements play in financial planning. The tax code is vast and, well, it's complex. It contains numerous regulations and rules that can be difficult to navigate. Understanding it is crucial for wealth management. Proper knowledge can help you minimize liabilities and maximize benefits. Trusts are legal tools that can protect your assets and also ensure their proper distribution. They offer a way to manage your wealth effectively. Both play vital roles in estate planning. They help in organizing your financial affairs and securing your family's future. Taxes are the government's way to fund services that benefit society. They support infrastructure, education, and healthcare. Estate planning ensures your wishes are followed after death. It provides a clear plan for asset distribution. It involves deciding how your assets are distributed. This can include property, investments, and personal belongings. Tax codes and trusts are intertwined. They impact how we manage wealth and influence how we pass it on. They work together to create a comprehensive financial strategy. This interplay is crucial for individuals and families. It ensures that wealth is preserved and transferred efficiently. Mastering these concepts can seem daunting, but it's essential for financial security. With the right guidance, you can navigate these complexities. This guide will simplify these concepts and empower you to make informed decisions. Stay tuned as we delve deeper into the world of tax codes and trusts. In Section 2, Unraveling the Complexities of Tax Codes, we delve into tax codes, which are sets of laws that govern taxation in a jurisdiction. These laws determine how income is taxed and how businesses are taxed. The Internal Revenue Code is the U.S. Federal Tax Code, and states also have their own tax codes. Understanding these codes is crucial for financial planning. Tax codes are complex and are subject to change. Staying updated is vital for compliance and also helps in leveraging tax benefits. Professional advice can be invaluable. Tax advisors can provide personalized guidance, helping you navigate the complexities of tax laws. Now, in Section 3, Subchapter C, Corporations and their tax implications, we explore how Subchapter C corporations are separate legal entities, distinct from their owners. This separation means that the corporation itself is responsible for its own debts and obligations. This distinction offers certain advantages, but also comes with specific tax implications that must be carefully considered. One significant advantage is limited liability, which protects the personal assets of the shareholders, shielding them from business debts and liabilities. This means that shareholders can only lose the amount they have invested in the corporation. However, C corporations face double taxation. Their profits are taxed first at the corporate level, and when these profits are distributed to shareholders as dividends, they are taxed again at the individual shareholder's income tax rate. This can significantly impact the overall profitability of the corporation. Understanding these implications is crucial. It helps in making informed business decisions and allows for effective tax planning. Proper planning can mitigate some of the tax burdens and enhance the financial health of the corporation. Finally, in Section 4, Navigating the Labyrinth, Estate and Gift Taxes, We cover how estate and gift taxes are levied on the transfer of wealth, either during life or after death. These taxes can significantly impact inherited wealth. The federal government imposes an estate tax, which applies to estates exceeding a certain threshold. Many states also have their own estate taxes. Gift taxes, on the other hand, apply to lifetime transfers of significant value. Understanding these taxes is vital for estate planning. Effective strategies can mitigate these taxes. Trusts, for instance, can be used to manage tax liabilities, ensuring the efficient transfer of wealth to beneficiaries. Section 5. Trusts, safeguarding wealth and legacy. Trusts are essentially legal entities that provide a robust framework for managing and protecting your assets, ensuring they are handled according to your wishes. They are established by someone known as a grantor, who sets terms and conditions of trust assets to institutions, who then manage these assets with care and diligence. They do this for the benefit of the beneficiaries, as detailed in the trust document, ensuring that the grantor's intentions are honored. Trusts come with a variety of benefits: asset protection, probate avoidance, and significant tax advantages, making them a powerful tool. They can be tailored for diverse purposes, such as estate planning, charitable giving, and special needs planning, providing solutions for various financial goals. Overall, trusts are versatile tools that offer flexibility and control over the management of your wealth, ensuring your legacy is preserved and your financial objectives are met. Section 6. Charitable Trust. Balancing philanthropy and tax benefits. Charitable trusts combine philanthropy with tax benefits. They allow individuals to support causes they care about while offering tax deductions. Donors can make contributions to these trusts, which are tax deductible. The trust then uses these funds to support charitable organizations. There are different types of charitable trusts, each with unique features. Choosing the right type depends on your philanthropic goals. Charitable trusts offer a win-win. They allow you to give back to society and also provide tax advantages. Section 7. The importance of professional guidance. Navigating the complexities of tax law and estate planning requires expertise. Seeking professional guidance is essential. It can help you make informed decisions. Tax advisors and estate planning attorneys are invaluable resources. They can provide personalized advice and help you develop a comprehensive plan. A financial advisor can also play a crucial role. They can help you align your investments with your financial goals. A team of professionals can work together to ensure your financial well-being and protect your legacy. Section 8. The ever-evolving landscape of tax law. Tax laws are constantly changing. Keeping abreast of these changes is crucial. It ensures compliance and helps you capitalize on new opportunities. Legislative updates, court rulings, and regulatory changes can all impact tax laws. Staying informed can be challenging, but utilizing resources like the IRS website, financial publications, and professional journals can help. Regular consultations with your tax advisor are also essential. Continuous learning is key to navigating the dynamic world of tax law. It empowers you to adapt to changes and ensures your financial strategies remain effective. Section 9, Conclusion. Securing your financial future. Understanding tax codes and trusts is paramount. They are fundamental to wealth management and estate planning. This understanding empowers you to make informed decisions that protect your assets and provide for your loved ones. While the complexities can seem daunting, remember that knowledge is power. By investing the time to learn and seeking expert guidance, you can confidently navigate the intricacies of tax law and secure your financial future. Remember, proactive planning is key. Don't wait until it's too late to start thinking about these crucial aspects of your financial well-being.
So there are clearly situations, and through my relationship with the third-party administrator, I'm exposed to a good many situations where client expectations are simply not being met. And almost nobody knows what they're being charged inside these policies. And few of those know what they're actually getting in performance. Most of the purchase decisions are made based on hypothetical projections of some rate of return. It's the most ironic thing in the financial services industry to me is high net worth individuals, which is almost by definition somebody who's going to establish an insurance trust as a high net worth individual. They'll establish a small account for a grandchild, and in passing, almost invariably ask, what's the past performance been of the fund that we're going to put this money in? But at the same time, we'll put tens of thousands or hundreds of thousands, or in some cases millions of dollars into a life insurance policy, and never ask, what's the actual performance that I'm getting? I see this hypothetical, but what's the actual performance I'm getting? And all of that stems to the use of these hypothetical illustrations, which have very legitimate uses. But just like something that has a legitimate use, if misused, is not, if used for something it was not intended for, is not a legitimate use. The use of these illustrations, like in the Cochran case, where they were comparing one policy to the other to determine which one was better, the chief regulatory body of the financial services industry says that's a problem. Says that doing that can result to misleading information and misleading decisions, and is actually strictly prohibited if you are in a variable life context, which they were in the Cochran case. But the rule is not very well enforced, and so they went ahead and did it anyway, and the beneficiaries suffered the consequences. I often hear that, well, if it's not a variable product, then I don't have to worry about that. Well, I think worrying about using misleading information is just something that everybody should worry about. But even if you stick to the strict interpretation of the rules, so if it's not a variable policy, maybe the chief regulatory body doesn't have jurisdiction over a UL or a whole life, but the chief actuarial body of the life insurance industry also published a study that said comparing illustrations is fundamentally inappropriate. So for those interested in doing what's right for the client and using information that is reliable, the use of these illustrations is not a good idea for comparing which product may be better for a particular policy, for a particular client or a particular situation. And again, that's not to suggest that illustrations do not have utility. They're very good for ascertaining the appropriate funding level. They're very good for ascertaining or doing modeling and planning for cash flows. But as both the chief regulatory body of the financial services industry and the chief actuarial body of the life insurance industry, and most recently the OCC, they've all said that these illustrations are highly volatile and not reliable for making product decisions.
how to set up the BIT platform with RSI, CCG, and Affinet. Welcome to the future of integrated services. The BIT platform, short for banking, insurance, and transportation, is a revolutionary platform designed with the user in mind. It's a one-stop shop for all your banking, insurance, and transportation needs. Markets your life easier by bringing everything under one roof. The platform is the brainchild of 3 industry leaders. RSAE, a pioneer in artificial intelligence. CCG, a global leader in customer contact solutions. And Affinet, a top-tier affiliate network. Together, they've created a platform that's not only comprehensive, but also user-friendly. Whether you're a seasoned professional in the banking industry or someone just starting to navigate the world of insurance and transportation, the BIT platform is there to simplify your journey. Getting started is simple. Let me guide you through the process. First things first, you need to register. To kick things off, let's head over to the BT platform website. Here you'll find a button labeled Register. Click on it and you'll be directed to a registration form. This is where you'll need to provide some basic information: your name, email address, and your preferred login credentials. Once you've filled out these details, go ahead and submit the form. Now, keep an eye on your email inbox. You'll receive a confirmation email from us. This is not just a courtesy message. It contains vital instructions for the next steps. So, make sure not to miss it. This brings us to the second step of our journey: account verification. In the confirmation email, you'll find a verification link. Clicking this link will verify your account and activate it. Now, you might be wondering why this step is necessary. Well, verification is a critical part of maintaining the security and integrity of your account. It's a way of confirming that the email address you provided is indeed yours, and that it wasn't a typo or a fraudulent attempt. So, make sure to click that link. After you've clicked the verification link, you're officially a registered user of the BIT platform. But here's the thing, we're not quite done yet. To fully activate your account and gain access to all the platform's features, there's one more step you need to complete. This is the KYC, or Know Your Customer process. This involves providing some additional information, like identification documents and proof of address. Don't worry though, the platform will guide you through this process step by step, ensuring your documents are submitted securely. And there you have it. You're now a fully registered and verified user of the BIT platform. You're ready to dive in and explore everything the platform has to offer, from banking and insurance services to transportation solutions. Remember, verification is a vital step in securing your account. So, always ensure you've completed this process before proceeding. Happy exploring. Now, let's move on to the Know Your Customer, or KYC process. The KYC process is a crucial step in setting up your BT platform account, designed to comply with regulatory requirements aimed at preventing identity theft, financial fraud, and money laundering. To start the KYC process, you'll be asked to provide additional personal information. This typically includes identification documents and proof of address. These may be a government-issued identification, like a passport or driver's license, and a utility bill or a bank statement that confirms your current address. The platform will guide you through the process of securely submitting these documents. Rest assured, your information is protected with the highest level of security to maintain your privacy. Completing the KYC process not only verifies your identity, but also unlocks the full potential of the BT platform. KYC ensures your account meets regulatory requirements. Now, you're ready to dive in and explore all the features and services the BIT platform has to offer. With your account up and running, it's time to explore. Welcome to the heart of the BIT platform, where banking, insurance, and transportation converge. The layout of the platform is designed to be intuitive and user-friendly. At the top of the screen, you'll find the navigation bar, your compass to the 3 core services. There's the banking section, the hub of your financial management. Next, we have the insurance section, your gateway to a variety of coverage options. And lastly, the transportation section, your ticket to seamless travel and logistics solutions. The sidebar on the left houses your account settings, notifications, and support. Here, you can customize your profile, check your messages, and access help whenever you need it. The central panel displays your dashboard, a snapshot of your activities and services at a glance. As you venture deeper into each section, you'll discover a wealth of tools and features to streamline your operations. Understanding the platform's layout will help you navigate its features effortlessly. So let's dive in and explore the possibilities. Now, let's dive into the banking services. Imagine having a bank in your pocket. That's what the BIT platform offers you. In the banking section of our platform, you can access a wide array of services, each designed to make your financial life easier and more convenient. First off, we have the account opening feature. Whether you're looking for a savings, checking, or a business account, you can do it all right here. Simply follow the prompts, provide the required information, and voila, your account is set up. But what if you already have bank accounts elsewhere? No problem at all. The BIT platform allows you to link your existing accounts for seamless financial management. Just input the relevant details and you can view and manage all your accounts from one central place, reducing the hassle of switching between multiple banking apps or websites. Next, we have our robust transaction feature. Whether you want to transfer funds, pay bills, or make purchases, you can do it all within a few clicks. The platform is designed to facilitate smooth and secure transactions, ensuring your money gets to where it needs to go. But that's not all. The BIT platform also offers a range of investment options. Whether you're a seasoned investor or just starting out, you'll find a variety of investment tools and resources to help you grow your wealth. From stocks and bonds to mutual funds and more, explore the possibilities and make informed investment decisions. And let's not forget about the financial management tools. With features like budgeting, expense tracking, and financial goal setting, you can take control of your finances like never before. Banking services at your fingertips, isn't that convenient? With the BIT platform, you're not just banking. You're banking smarter, faster, and more efficiently. So why wait? Dive in and experience the future of banking today. Beyond banking, the BIT platform also offers insurance and transportation services. These services are designed to provide you with a comprehensive experience, allowing you to manage your financial and logistics needs in one place. Let's start with insurance services. Here, you'll find a wide range of options tailored to your needs. From life and health insurance to property coverage the BIT platform has got you covered. To apply, simply navigate to the insurance section. You can explore the different coverage categories and select the one that suits you best. Review the policy details carefully before proceeding. Once you've selected your coverage, follow the prompts to complete the application process. You'll be asked for some information, and in a few clicks, you'll be on your way to securing your future. Now, let's move on to transportation services. Whether you're planning a trip or need help with logistics, the BIT platform can help. With a diverse range of services, you can book flights, rent vehicles, and even arrange logistics, all from the convenience of your account. To start, go to the transportation section and browse through the available options. Once you've found your desired service, follow the instructions to complete the booking or arrangement process. It's as simple as that. But what if you have questions or run into problems? No worries. The BIT platform support team is always ready to assist. Whether you need help navigating the platform, have questions about a service, or encounter any issues, don't hesitate to reach out. They're just a click away. With BIT, managing your insurance and transportation needs becomes hassle-free. You have everything you need, all in one place. So, why wait? Start exploring these services today and experience the convenience and efficiency the BIT platform has to offer. In case you need help, remember, assistance is just a click away. Our dedicated support team is always on standby, ready to guide you through any challenges you might encounter while using the BIT platform. Whether you have a question about banking services, need clarification on an insurance policy, or want assistance with transportation bookings, we've got you covered. You can reach out to the support team via the help or contact us options on the platform. Our team is committed to providing you with swift and effective solutions, ensuring you have a smooth and hassle-free experience. With the BIT platform, you're never alone in your journey. You're now ready to experience the seamless integration of banking, insurance, and transportation services on the BIT platform. Enjoy.
At the same time, we've got this asset that we've already discussed is, I call it the last largest, most neglected asset on clients' balance sheets. It's in desperate need of management. People don't know what they're being charged. Clients don't know what they're being charged. Trustees don't know what they're being charged. They don't know what they're getting in the way of actual performance. So it is clearly the last largest, most neglected asset on clients' balance sheets. So policy reviews are absolutely essential. The problem is that there are some policy review providers who are doing the reviews in a way that measures expenses, measures performance, and generally follows prudent investor principles, the same type of reviews that we would do on just about every other financial instrument in the financial services business industry. But there are also others that are using the misleading practices that FINRA cautions against and that the Society of Actuaries deems fundamentally inappropriate and the OCC says is volatile and unreliable. And so it's really no wonder that complaints and arbitrations and lawsuits are on the rise. Some of these practices are clearly behind the Cochran case, which I already talked about. There's another case against a bank, a ILET trustee, in which the plaintiff was French. Some of you on the call may be familiar with the activities in the stranger-originated life insurance area. I already mentioned 419 and 412I, and all of these things are giving rise to more and more complaints, not just for the estate planning attorney, but really for all practitioners. I see life insurance as or the plaintiff's bar looking for, like a heat-seeking missile, looking for a target for clients who are disappointed in their performance of their life insurance. So enough of the bad news. The good news is that about 2 years ago, the Financial Planning Association, 3 years ago, the Financial Planning Association formed a task force to help define or to apply established prudent investor principles.
Greetings. We're back, and let's talk about the concept of negotiability. States here the concept of negotiability is one of the most important features of negotiable instruments, and largely because of this feature, negotiable instruments are highly trusted and used daily by millions of people. When an instrument is transferred by negotiation, the person receiving the instrument is provided with more protection than were available to the person from whom it was received. The person receiving the instrument is able, in many instances, to recover money on an instrument, even when the person from whom the instrument was received could not have done so. Let's break that down. When an instrument is transferred by negotiation, the person receiving the instrument is provided with more protection than was available to the person from whom it was received. The person receiving the instrument is able, in many instances, to recover money on the instrument, even when the person from whom the instrument was received could not have done so. Instruments that do not meet all requirements of negotiability cannot be negotiated. I'll repeat. Instruments that do not meet all the requirements of negotiability cannot be negotiated. However, they can be transferred by assignment, which is governed by the ordinary principles of contract law. People who receive instruments by assignment are not given special protections provided those who receive instruments by negotiation, because they cannot be the holder in due course, which will be explained in the next chapter. Negotiations by endorsement. An instrument is endorsed when a holder signs it, thereby indicating the intent of transfer ownership to another. Endorsements may be written in ink, typewritten, or stamped with a rubber stamp. They may be written on a word processed on a separate sheet of paper called a writer or an allonge, as long as the separate paper is so firmly affixed to the instrument that it becomes part of it. Although the UCC does not require endorsements to be on any particular side of the paper, for convenience, they are usually placed on the back of the instrument. Anyone who gives value for an instrument has the right to have the unqualified endorsement of the person who transferred it, unless it is payable to bearer. And they give you an example of a negotiable instrument. This is the check. That's the front of it. This is the back of it. You see what the institution, reserved for depository bank, and then reserved for subsequent endorsement. So you got on the back, you got 3 places where these institutions can negotiate the instrument. And I want you to pay attention to this, and this is under Regulation CC. So if you're going to be doing an instrument, you need to understand that there's a place for the depositor to quote unquote endorse. There is reserved for the depository bank, the bank of first deposit, and then reserved for any subsequent bank endorsement on the third part. Now, Regulation CC has issued check endorsement standards. Regulation CC, issued by the Federal Reserve Board under the Competitive Banking Act, has established standards for check endorsements. Under the regulation, the back of a check is divided into specific sections designed to protect the endorsement of the depository bank, the bank of first deposit. The first 1.5 inches of the trailing edge of the check is reserved for the payee's endorsement. Negotiations is effective to the transfer Negotiations is effective to transfer an instrument even when it is transferred by a minor, a corporation exceeding its power, or any other person without capacity, obtained by fraud, duress, or mistake of any kind, part of an illegal transaction, or made in breach of duty. Any such negotiations, however, will be rescinded except as against a holder in due course, defined and explained in the next chapter, who is given special protections. There are 4 commonly used endorsements: blank endorsement, special endorsement, restricted endorsements, and qualified endorsements. Let's look at Regulation CC more carefully. For laughs and giggles, let's say this is a negotiable instrument in M3 conveyance, and this instrument is going to be considered a bearer instrument. A bearer instrument doesn't require a signature and the required depository endorsement. The bearer instrument could simply either in pass, in part, provide, especially if a notary is doing this. And I'm going to slide right into while you're listening. The notary can endorse in that section that says reserved for depository bank, and with special bankers acceptances and a signature medallion guarantee. In other words, the signature medallion guarantee would go right there, thus making the instrument an M3 conveyance. And once you have an M3 conveyance, it's just a matter of deciding which local court is going to serve in this section. See, this section here is where the notary will attach the signature medallion guarantee. This section here is where the clerk of court would endorse. Keep listening, because if you listen long enough, you will learn something.
Got your number, Mr. Carlin. Yeah, that's true. That's true. Keep them UV rays off of me. In the Securities Trades Commission, they have what you call is a prospectus, and a prospectus what? Supplement. And the Securities Trades Commission, SEC, they have what they call as what? A prospectus and a what? Prospectus supplement. So you notice how I sent the notice, right? And the notice says prospectus. You come down, brother? Thank you. Prospectus what? Yeah. Listen, I'm going to show you something. See, the brother put it, this should have been first. It's an array of, or review of, prospectus of who? Investor. I didn't say mortgagor. Right. Do you hear me what I'm saying? You're not a mortgagor. You are what? Investor. So we want to communicate, because I already showed you from the securitization audit that they're taking your mortgage and putting it into a mortgage loan trust, and they're issuing what? Trust certificates to the investors. But remember, you're the one who signed the note, right? So it's saying here, right here, this is to who? Kevin Trardon. Who is he? Vice President of who? Now check this out. This notice of prospectus payout pertains to the who? The mortgage loan transferred to the who? Mortgage Loan Trust 2007-6. I had purchased and invested. I didn't say I got a mortgage. Do you hear me what I'm saying? Because if you say you got a mortgage, you wonder why they ain't responding to you. That's right. Because you're talking like a slave. Right. So listen to what they're saying here. I had what? Purchased and invested on this same said mortgage loan trust as a who? Note holder. Because remember, you signed it in blue. Nope. So you are the note holder. Do you hear me what I'm saying? Yeah.
The process that the courts recognize as leading to prudent decisions taking those same prudent investor principles and applying them to life insurance, to provide all advisors, attorneys, trustees, financial planners, with guidelines for how do you go about prudently selecting a life insurance policy? How do you go about properly managing a portfolio of life insurance? That task force led to best practice standards for life insurance stewardship that was finalized at West Point in 2013. The draft that's currently available online, for anybody who's interested, again, if you would like a PDF copy, you are welcome to email me. You can also go to the Leadership Center for Investment Stewards, which is the body that manages or safe keeps the standards. And there's a version on their website that the standards are in the public domain or the public comment period. So that West Point draft is now available or being presented for public comment. You can also view it there. But the standards in their current form were put together by not just insurance professionals, but also include the perspective of the estate planning attorney. It also included the perspective of the institutional life insurance trustee, because the largest third-party administrator of trust-owned life insurance for those institutions was part of the West Point draft. The Financial Planning Association, which is the largest association of certified financial planners, which are RIAs and other investment professional fiduciaries. A leading financial planning university, Texas Tech University, participated in the standards, and 6 of the largest independent distributors of life insurance. So just about every perspective of, or just about every profession who has clients who has life insurance, their perspectives were addressed in these standards. And it takes the same universal decision-making framework already well accepted in the investment business, commonplace in the investment business, and applies it to life insurance, which makes talking about life insurance as an asset a whole lot easier, because we're not using insurance jargon or insurance-specific vernacular. We're using concepts that are well established in just about every other segment of the financial services industry and applying them to life insurance.
All right. Is that you, Dr. Livingston?
Hello?
Hello.
Hello there. Yes, this is Dr. Livingston.
Great. Glad you can make it. This is Rocco.
I did. Yeah, actually, I made it about 45 minutes early. And the folks told me, so you're about 45 minutes early. But they said it sounds like an interesting call. All right.
Cool.
So you guys open up to tell me, I guess, who you guys are, and I'll try to give you a little bit of my background, and then we'll go from there.
Well, we're just 2 guys, Bo and Rocco, and we're tangling with the law.
Okay.
Basically, 2 regular guys, probably 3 years into it, and we've stumbled, tripped, and fallen, but we're still on our feet. And
all right. So you are. This is a radio show, though, right?
Correct.
All right. So we're going out over the airways, I'm assuming.
Absolutely.
Okay. That's good.
Well, people listening on their phones, so it's all good.
Good deal.
Yeah.
Okay. Where would you like for me to start?
Why don't you tell us about yourself?
Well, as I was going over with the other folks, I've been at this legal issue for quite a while. Mm-hmm. And I started in 94, 95, as just a little student in law, and came out of that. My first case I won. It involved my discovery of something that most people can't even begin to understand. And it's called that in any criminal case, state or federal, doesn't matter, in any criminal case, no one has the right to a trial by jury. Now, that usually shocks everybody, and they go, no, we got a right to trial by jury, and my comeback is, no, you don't. This has been a deception for a long time. It's a fraud, and on the surface of it, it sounds like judges would love that, but they actually don't. They hate the argument because it leaves them somewhere they really would rather never be. It is, as I said, the biggest fraud, one of the biggest frauds in the country, this country as well, especially. And you'd say, well, how does that work? What do we mean by no right to trial by jury? Well, it starts out at Article 3, Section 2, Clause 3 of the U.S. Constitution. And before we examine this particular part, we want to lay a few words, groundwork lies down. The first one is the word trial. The word trial comes from the word try. And if I were to ask you, if you were to try out a new car, who would control the car? The expected response would be, I would. And that would be right. You would control the car. If I were to ask you, if you were to try on new clothes, who would control the clothes? And you would say, I would. And that would be right. The reason for that is the word try means, or goes to, control. And if you're driving the car more than a time or two, you're no longer trying it, you're driving it. And if you're putting on the clothes every day and so forth, you're no longer trying them on, you are wearing them. So we understand that try goes to this thing called control, and trial goes to control process. And in either case, the concept of try or trial means to go through this new experience for the first time, for one time or a limited number of times before that changes. And it goes to the issue of control. Now, the word shall goes to, we find the word shall in the 1785 Samuel Johnson Dictionary, the American Dictionary, and it goes to the word, or the actual goes to the Saxon rendering of I owe or I ought. That's how it's defined. I owe or I ought. Shall means obligation or duty. And so we get that part, shall. The word all in any of the dictionaries is just really how it sounds. All means everything and nothing excluded and so forth. We go to Article 3, Section 2, Clause 3, and there we find a little phrase we'll call a parenthetical phrase. It's offset by commas, but it's called parenthetical. Okay, now, it says, except in cases of impeachment. Well, people don't go into court to be impeached, not as a rule. That's usually something for legislatures to try certain kinds of officials. So what we want to do is say that term, except in cases of impeachment, doesn't apply to the ordinary case, and so we're going to exclude it, or we're going to kind of jump over it, okay, where it's at, and read straight through. That would render this whole thing, this Article 3, Section 2, Clause 3, as the trial, control process, right? The trial of all crimes shall be by jury. Now, what did I do there? I've read straight across, and now we get this picture. The trial of all crimes shall be by jury. Wait a minute here. I've got a different copy of the Constitution. Let me see if mine matches yours. You've probably got one. So the trial of some crimes, excuse me, let me go back up there. The hearing of some crimes may be by jury under the direction and supervision of a judge. Now, does anybody read that anywhere?
No, what version you got? I have the trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the
right.
state
Okay,
where...
so you don't have that version I just made up.
Not in front of me, anyways.
so you don't have the version I just made up, right?
No.
All right. Okay. Well, I did this for a reason. You know, I said under the direction and supervision of a judge, and that's not there, is it?
Correct.
And so the question is, how is the judge getting into the trial if the word trial means control process? The jury is supposed to control it, so how does the judge get into it? Well, for that, we're going to go to the Sixth Amendment. This is where it's coming from, the Sixth Amendment. In all criminal prosecutions, comma, the accused shall enjoy the right to a speedy and public trial, comma, by an impartial jury. Now, in principles of law, whenever we hold two similar laws with language and so forth, we hold them together. We do that in order to get a good picture of what the final rendering of the law or the discerning of the law is. We hold the two laws together. In this case, in all criminal prosecutions, that holds tight to the trial of all crimes, right? In fact, two things here. First of all, this is known as in para materia. I-N space P-A-R-A space M-A-T-E-R-I-A. In para materia. And it means to hold two like worded laws together in order to discern the right, the correct meaning of that law. Okay, so in para materia. We also go to June the 8th, 1789. We find James Madison, as Congressman Madison, has just presented the Bill of Rights to the Congress. All right, it's all in the records. He's done this, quite lengthy actually, and he's really the father of the Bill of Rights as well, because he's the one that really truly introduced it for the first time. He actually puts in there precisely as I've just discerned it. He says he's proposing this amendment. The bill, he says, the trial of all crimes shall be by an impartial jury. Okay, all right. He's really targeting Article 3, Section 2, Clause 3. Because, you see, there was a problem. He realized that we needed to change, we needed to insert the one word, impartial. All right, so the trial of all crimes shall be by impartial jury is the way it is truly to be construed. Okay. Now, at this point, we want to do something kind of important. We've got the except in cases of, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Now, you have that comma after the word trial this time, and you can't actually jump the word right over the comma. Grammatically speaking, it's not correct. But everyone wants to say, yes, I have the right to trial by jury. I see it there. I see the word right. So I want a trial by jury. Now, you know, anytime you have an actual right that's personal to you, you can waive that right, can you not?
Yes.
Right?
Right.
Yep.
Okay. So you can waive that right, and let's play devil's advocate. Let's go ahead and extend the right over the comma, and it's now going to connect to the impartial jury. Having the right to an impartial jury, you can now waive it, can't you?
If you so choose, I would think, yeah.
You could do that. Okay. Here's the first question. Question 1. What is the opposite of an impartial jury?
A biased jury?
A judge.
Partial. Okay, you're right. Partial jury, right? Prejudiced or biased, partial jury, right? And we know that would violate the Fifth Amendment, right? We know that's not due process of law, correct?
Correct.
Okay, so we can't really waive the right to an impartial jury and get a partial jury, can we? You wouldn't think so? Let's try this one more time. Let's just ask the same question, but we're going to respond to it differently. And the answer is not a judge. All right? The answer to the question is, what is the opposite of an impartial jury? The answer is not a judge. Are you getting that?
Not a judge.
The answer to the question of what is the opposite of an impartial jury is not a judge. Not a judge. You can't waive your right to an impartial jury and get a judge.
Implementation Guide, M3 Conveyance and Syntactical Trusts. Introduction. This implementation guide aims to demonstrate the proper execution of M3 conveyance within syntactical trusts, specifically focusing on the integration of bank-owned life insurance, BOLI products. By following this guide, civil law notaries, parliamentary draftsmen, and compliance officers can gain a comprehensive understanding of the process and successfully navigate the complexities of M3 conveyance. Step 1. Understanding syntactical trusts and BOLI. Before diving into the implementation of M3 conveyance, it is crucial to have a solid understanding of syntactical trusts and bank-owned life insurance, BOLI. Syntactical trusts provide a hierarchical framework that allows for the expansion of trusts in various directions, particularly beneficial for sovereign entities. BOLI products, on the other hand, involve purchasing life insurance on key employees or directors with the trust as both owner and beneficiary. Step 2. Assessing the types of BOLI products for syntactical trusts. Within syntactical trusts, there are 3 primary types of BOLI products: general account, separate account, and hybrid account. Each type offers unique features and benefits, and it is essential to assess which type aligns best with the goals and objectives of the trust. Step 3. Establishing the M3 conveyance framework. The next step is to establish the M3 conveyance framework within the syntactical trust. This involves creating a comprehensive plan that outlines the roles and responsibilities of the involved parties, the legal and compliance requirements, and the specific procedures for implementing M3 conveyance in conjunction with BOLI products. Step 4. Integration of BOLI into the syntactical trust. Once the M3 conveyance framework is in place, the integration of BOLI into the syntactical trust can begin. This includes identifying the key employees or directors eligible for life insurance coverage, determining the optimal BOLI products based on the trust's objectives, and coordinating with insurance carriers to initiate the necessary policies. Step 5. Accounting and compliance considerations. Proper accounting and compliance practices are crucial when implementing M3 conveyance with BOLI products. Compliance with FASB Technical Bulletin No. 85-4 is essential, as it governs the classification and reporting of BOLI assets on the balance sheet. Understanding the accounting treatment and compliance requirements will ensure accurate financial reporting and adherence to regulatory standards. Step 6. Ongoing monitoring and evaluation. Implementing M3 conveyance within syntactical trusts is an ongoing process that requires monitoring and evaluation. Regular reviews of the BOLI products, the performance of the trust, and compliance with legal and regulatory obligations are necessary to ensure the continued success and effectiveness of the M3 conveyance framework. Conclusion. By following this implementation guide, civil law notaries, parliamentary draftsmen, and compliance officers can navigate the complexities of M3 conveyance within syntactical trusts successfully. The integration of BOLI products offers a sophisticated and advantageous approach to managing assets within these trusts. It is crucial to approach the implementation process with a comprehensive understanding of syntactical trusts, BOLI products, and the legal and compliance considerations involved.
North Avenue Capital started with a vision of being the best lender in the industry. For us to be effective, we needed to understand rural communities and the businesses that are critical for keeping those local economies thriving. North Avenue Capital provides financing in partnership with the USDA Rural Development Program. The main purpose of the USDA Rural Development Loan Guarantee Program is to encourage lenders to deploy capital into rural communities with the underlying objective of creating jobs, spurring on economic development, and helping establish and build businesses in communities outside of large metropolitan areas.
The USDA Business and Industry Loan Program is a secured asset lending program. We refinance existing debt, we do ground-up construction, we provide capital to improve real estate and provide working capital to borrowers across the country. The benefits of the USDA B&I program are the rates tend to be very competitive. They're very long-term loans, up to 30-year term and amortization. It tends to be a highly levered product, so oftentimes we can get up to 75% loan to cost on startups, and on the right existing business, we often do 100% financing. The types of deals that can be done in the USDA B&I program are all forms of commercial real estate, office, industrial, retail, hospitality, but then also specialized sectors, vineyards, wedding venues, nurseries, family entertainment centers, even oil and gas and mining.
In order for a borrower to qualify for a B&I loan, first of all, they have to be a for-profit business or a startup business, but they need to be located in a rural community outside of a big city, which actually comprises 97% of the country. In fact, many borrowers are operating in rural communities and may not even know it because of their proximity to a suburban or metropolitan area.
If you have an opportunity that you think may be a fit for one of the USDA loan programs, you can find us at northavenue.com, and we're all over the internet. We look forward to working with you.
The alternative lending industry can provide a very lucrative opportunity for brokers and affiliate partners. Whether you're specialized in commercial lending or real estate financing, having the right funding partner can make the difference between earning thousands on a deal or losing a commission. Go Capital understands this. You work hard to secure your clients and deserve to be compensated. Unfortunately, due to increased competition, many lending companies have stopped working with new agents, are not providing adequate training, are slow to respond, and simply not issuing competitive approvals. By joining Go Capital's partner program, your dedicated support specialist will assist you every step of the way. As a broker, you know that it's not always a matter of obtaining a loan approval. You need competitive terms. Go Capital's catalog of loan products allows you to offer the best financial solutions to your clients. Options include business lines of credit, SBA loans, merchant cash advances, commercial mortgages, hard money fix and flip loans, bridge financing, equipment leasing, invoice factoring, and more. What does this mean for you? More deals, more commission, and satisfied customers. As a registered partner, you'll receive free access to the Broker Affiliate Sales Portal. This system allows you to easily manage your deals and also offers tools, training, and resources that will help you succeed. Frustrated with never being able to speak with someone about your deals? At Go Capital, someone is always available. Whether you prefer to call, email, chat, or even visit our office headquarters in downtown Miami, we are always available to answer your questions. While other companies may advertise the highest commissions, they often fall short when it comes to issuing competitive terms, making the process easy, or simply being responsive. Go Capital provides quality broker support and training, and quickly identifies how to best structure a transaction. With our multitude of loan programs, comprehensive training systems, and quality service, you can focus on more important things, generating more business. Need us to join a conference call with a client? Need help presenting an offer? No problem. Our loan specialists are here to help. For more information or to sign up, visit our partner page on www.gocapital.com today or call 1-866-257-2973 and speak with an account manager. Go Capital, where your success is our business.